is fabricated and fake.
Okay, Mr. Loma Muralte, learned counsel for the appellant, submits that the income of the deceased has not been proved, and that the policy
Yes, my lord.
is also fabricated. In view of above, let the appeal be admitted. Call for the LCR.
My lord, LCR is here.
Are they? Then why do you say that LCR?
I'm not aware of.
Then you cancel that. Parties are represented. Please read the sentence. Okay, from the ICAT. List the matter again after a week for admission. If the respondents numbers 2, 3, and 4 remains unrepresented, court may consider proceeding with the matter.
Obliged, my lord.
All right.
Item 5.
Yes, what is this? Clarification?
My lord, this court had disposed of WPC number 66/2024, white order dated 4/7/2024. This order was disposed of in line with the order dated 6/5/2024, passed in WPC number 64 of 2023. The direction of this court in this order is that, my lord, the petitioners herein were entitled to grant the benefits of notification dated 2013 and 2/7/2014 for the purpose of their placement to senior grade and selection grade. And for that purpose, my lord, the direction was given by giving a liberty to the state respondents to verify as to whether the petitioners have rendered continuous service from SSA till regular appointment in the regular post. But, my lord, here there is misconception on the part of the state respondents. They have issued one order dated 1/5/2025, which is at page number 51. In spite of this, Honorable Court had already held the entitlements of the petitioners, yet they have examined by the entitlements of the petitioners by misinterpreting the scope of scrutiny and verify liberty given to them. Page number 51, my lord. Whereas judgment order dated 4/7/2024 was passed by the Honorable High Court in WPC number 66/2024, giving the state respondents liberty to verify and scrutinize the service particulars of all the petitioners. And whereas contempt petition numbers such and such in connection with judgment and order dated 4/7/2024 in WPC number 66/2024 was filed by the petitioners. And whereas the service of the petitioners were scrutinized and examined as per the liberty given by the judgment and order dated such and such. And whereas the government have in the past made an error of granting the counting of past service on similar case. Such errors made by the government regarding the counting of past service should not be interpreted as a precedent to justify future similar case. Now, therefore, the government, after careful consideration of all the facts and circumstances, and upon exercising the provisions of Clause 3 of the Mizoram Government Counting of Past Service Rules 2020, cannot entertain the petitioner's claim of counting of past service, as the said rules does not entail provisions of counting of past service for direct recruits under the government of Mizoram. Here, my lord, in the referred judgment of the order which I'm seeking to clarify, my lord, it was already held by this court that the rules of 2020 is not applicable to the case of the petitioners.
What is the order which is seeking clarification? 4/7/24.
4/7/2024.
Last in WPC 66.
Yes, my lord.
Please show me that portion.
Para 4, my lord, please, number 23, para 4. Submission of the petitioner.
Please read.
The Land Counsel for the petitioners, Mr. Such and Such, has also drawn the attention of this court to the common judgment order dated 6/5/2024, passed by this court in WPC number such and such, by which the service of the petitioners therein rendered under the CSS and on ad hoc basis followed by the regularization as government teacher was directed to be considered in terms of the notification dated and the collegium dated such and such. The Learned Counsel submits that the case of the petitioners are also similar and they are squarely covered by the said judgment and order. Para 5. Mr. Such and such, Learned Additional AG, submits that prima facie it appears that the case of the petitioners may also
Okay, just a minute, Mr. Victor.
Yes, my lord.
Where is the sentence wherein we say that this 2020 is not applicable to
Yes,
your
my lord.
case?
That is in the referred judgment under 6/5/2024.
Is it available here?
Yes, my lord.
Where is that? Page number?
It is in page number 34
34.
of the instant application.
Operative portion.
Operative portion is in page number 47.
47, paragraph.
Paragraph 17.
Please read.
The stand taken by the respondents is that the rules of 2020 was made effective from the date of publication in the Mizoram Gazette, that is 29/5/2020, and by the clarification on the implementation of the rules of 2020 issued by Office Memorandum dated 22/1/2021. The rules of 2020 is applicable to all employees with prior service rendered as specified under Rule 2 of the rules of 2020, irrespective of their date of regularization, whether before or after the said rule came into force. It may, however, be seen that Rule 2 of the rules of 2020 is applicable to all Group A, B, C, and D employees with prior service rendered as work charge, contract, provisional, or any ad hoc officiating employees under the government of Mizoram, including service rendered under CSS or any other scheme-borne post, and deficit ad hoc government-aided schools upon their regular appointment to the same substantive post. What can be noted from the said provision is that Rule 2 speaks about application of the rules to those employees who were given regular appointment to the same substantive sanction post. The petitioners in the present case have not been regularized or confirmed against the same substantive sanction post, and therefore cannot have any application to their case. The clarification made to OM 22/1/2021, clarifying that the rule will apply to everyone irrespective of the date of regularization before or after the rules of 2020 came into force, can also be not made applicable to the case of the petitioners, particularly in view of the fact that the rules of 2020 was framed under Article 309 of the Constitution, whereas OM dated 22/1/2021 is only a clarification in the form of an executive instruction.
Oh, just a minute. That OM of 2020 is applicable prospectively.
Yes, my lord.
But in view of the office memorandum,
Yes, my lord.
it has been made retrospective.
Yes, my lord.
And court has held that the retrospective effect cannot be done.
Yes, my lord.
So 2020 will apply, but it will only be applied prospectively.
Prospectively.
So your case is not covered by 2020,
Yes, my lord.
isn't it? But
This
see,
court had already held
so
that.
see, Mr. Victor, now they have passed some order. Rightly or wrongly, they have passed the order. Now, there is no point making a clarification now and trying to compel them, you redo the entire thing. Instead, why don't you do one thing, you challenge this order
My lord,
by
this
appropriate
order which
procedure.
I referred, 1st May 2025, it has no substance. This court has already held that we are not covered by the rules of 2020. And again, this order also says that we are not covered by these rules. It does not have any substance. But in view of this order, my lord, the respondent authorities are misconceived in interpreting the scope of scrutiny and to verify.
Okay, so.
The meaning, the purpose and direction given in this case, my lord, page 49, para 19, page 49. If I may continue to allow to read.
Yes.
Therefore, upon due consideration of the case in its entirety, I am of the considered view that the petitioners are entitled to be considered for counting their past service rendered prior to their regular appointment in terms of notification dated such and such. Accordingly, the respondents are directed to process the case of the petitioners for counting of their service rendered under such and such. In doing so, the respondents' authorities concerned will be at liberty to verify and scrutinize the service particulars. Here, my lord, the direction and liberty given to them is that whether the petitioners have rendered continuous service from SSA till regular appointment.
I understand, Mr. Victor, but the thing is that, like I said, rightly or wrongly, they have passed one order here, which is an order dated 1st of May. You challenge this order.
This does not reject our case, my lord. This order did not reject our case.
How do you say that?
Because, the last paragraph, my lord, keeping in mind the fact that the rules of 2020 did not cover the case of the petitioners, my lord. Last paragraph. Now, therefore, the government, after careful consideration of all the facts and circumstances, and upon exercising the provisions of clause rules 2020, cannot entertain the claims of the petitioner's claim of counting of past service as the said rule. As the said rule does not entail provisions of counting of past service for direct recruit under the government of Mizoram. Our claim, the benefits that we are claiming is under the notification dated 19/7/2013 and the corrigendum dated 2/7/2014. This court had already held that we are not covered by the rules of 2020. And in line with that, they have, why this order dated 1st May 2025, they're saying that we cannot be considered under the rules of 2020. It does not reject the claims of the petitioners in the direction made by this court to grant benefit of notification dated 2013 in the corrigendum.
So
2014.
if it does not reject, what benefit are you getting then? Tell me.
My lord, what I mean to say is that,
You're not getting any benefit. They're not considering you at all.
no, my lord,
They say that you're not covered, there's no provision for you to count the past service under these rules.
yes, my lord, we are not covered by these rules. The direction of this court is to grant benefit under the notification dated 19/7/2013 and the corrigendum dated 2/7/2014. If I may take a lordship back to the operative portion of the last of the order which I'm referring.
But still, I feel that you should file a writ petition, not by way of clarification.
My lord, kindly come to page number 24, para 6. We are not aggrieved with this 1/5/2025. Para 6, page 24.
If you're not aggrieved, why have you come before this court?
Because in view of this 1/5/2025, my lord, it is apparent that the respondent authorities are misconceived in interpreting the scope of liberty given to them to verify and scrutinize the service particulars of the petitioners.
See, this order will have to go, will have to be set aside, isn't it?
No, my lord, no, my lord.
Now, why should we clarify the government's order?
I'm not seeking for clarifying of the government order. I'm seeking
They've
for
already passed
clarifying-
one order. They've already passed one order here,
Yes, my lord.
1st of May 2025, misconstruing the court's order. So, why should this court clarify its own order again? What I meant was this, we have gone for this. So, I believe you should challenge this order, say that they have gone in the wrong direction, not by way of clarification.
That portion will be taken care in the jurisdiction of contempt proceeding, my lord. Contempt is pending at this moment. If I may take a lordship to page number 24, para 6. Para 6. Page number
I've
24.
read it, Mr. Victor.
Yes, my lord.
I've already read it.
This court has held that we are entitled to the benefits of this notification 19/7/2013 and corrigendum dated 2/7/2014. And we are not covered by the rules of 2020. And respondents were given liberty to scrutinize as to whether we have rendered continuous service from SSA till regular appointment. We are not we do not have any grievance with this 1/5/2025 order.
Then you wait if you're not agreed with this. You wait for your regularization of your counting of your past service. If
By
you're
this
not-
order, my lord, it is apparent that the state respondents were misinterpreting the direction liberty
So you
given.
challenge the misinterpretation. That's simple as that. They have not considered you as per the direction of this court, and they have passed some separate order saying that we cannot consider because the rule doesn't
I have
provide.
already filed contempt petition that will make submission in that regard. But to avoid future confusion and
No.
misinterpretation, I'm seeking for this clarification.
We will not give any clarification. By this IA will not give any clarification. You file a writ petition if you want to. We'll see in that. We'll make things more clear in that. And do away with this order. You challenge this order also, you seek for setting aside, although you may not be affected, as you say. But this comes in the way. They say that we are not bound to consider your case.
Under the rules of 2020. And this court also already held that we are not covered by rules of 2020.
Then in the contempt, they file this
Not yet,
order.
not yet.
They'll be filing this order
I believe so.
and say that we have complied with it.
Yes, ma'am. And in that contempt proceeding, of course, we can say that this is not the direction of this court. But to avoid future confusion, my lord, if
Let
one
it-
line can be passed, make clarification that the scope, the liberty given to the respondents is to verify only to the extent of whether the petitioners have rendered continuous service to SSA to till regular appointments.
Not in this IA.
Then I may be allowed to withdraw this.
You withdraw, you proceed with the contempt, and if you think it's proper, you may consider filing another one, wherein we'll put it in verbatim. As paid for by Mr. Victor L. Raute, learned counsel for the applicant, the matters application stands to be withdrawn.
Mr. Bhai.
With liberty
Yes, my lord.
to file appropriate applications as may be permissible in law.
Lordship,
Admission item 1.
pleadings are completed and the matter can be disposed of in a manner, in a similar manner in which other matters were also disposed of, Your Lordship. This is a matter regarding non-payment of solicium and interest in respect of those landowners. Those lands have been acquired in connection with border fencing.
Okay. Let it come up in the coming week. Tuesday, Wednesday. Mr. Nsiama, you are there in this case. You are appearing for whom?
I'm appearing for respondent number 5, NBCC.
NBCC.
NBCC,
And CGC is there?
implementing agency. I am an implementing
I
agency.
see.
Respondent number 5.
Respondent number 5.
Okay. So have it next week, some other day, which will be convenient to you.
All right.
Wednesday
Fixed
or
date.
Tuesday?
Wednesday may be a DB day. Last
Or maybe DB also, yes.
Thursday?
Thursday.
Thursday? All right. The parties are represented by the respective councils and they submit that the pleadings are complete and the matter may be taken up for admission hearing on Thursday next. In view of above, list the matter on 19th of June 2025 for admission hearing.
Item 2.
My lord, this matter also can be fixed on next Tuesday, my lord.
Tuesday.
Yes.
Your good name?
Izzaudin Sama.
And you are there also.
Yes.
Parties are represented by the respective councils and they submit that the pleadings are complete and the matter may be taken up for admission hearing on Tuesday next. In view of above, list the matter on
17, my lord.
17/6/2025.
Much obliged.
Item 3.
Your Lordship, in this matter, in the last court date, I was given the last chance, even though this is only the third time that the matter is listed. I was given the last chance to file the affidavit in opposition. Your Lordship, today I'll be filing my affidavit in opposition. Today, yes. I just have to get a legible copy of the annexures from the department, which I believe that they will be able to furnish within the forenoon.
You should type it out. If it's not legible, then you should type it out.
Yes.
They may try to make one more photocopy, which is more legible, but ultimately, it's more advisable if you can type it out. Anyway, Mr. Ramzawa, they're filing it today, it seems. Ms. Mary L. Kiante, learned government advocate, submits that she'll be filing the counter affidavit of the respondents during the course of the day. In view of above, let the matter be listed again after a week. Yes.
To be obliged.
Hearing item 6.
Mr. Lal Soirama, does he come to court nowadays?
No, Your Lordship.
Mr. Malhotra is also in this case. None appears when the matter is called. None appears for the, you're right, you're for the appellant? No, you're for the respondent?
The state.
None appears for the appellant when the matter is called. For ends of justice, list the matter after a week, 2 weeks. List the matter again after 2 weeks. So next week you'll be having full session, I hope. It's the last day for me today. Okay. Thank you.